I'm Elana Telfer, one of the ER advisors, and it's time for a quick heads up on the news from the world of employment law. This month I'm going to be looking at a recent High Court case where an employer sought to enforce a restricted covenant following a long period of garden leave. So what are restricted covenants? Well, these are clauses contained within the employment contract relating to what happens after the employment has ended. They tend to be used to restrict employees who may use confidential information gained during their employment for the benefit of their new employer or for their own purposes. They're deemed enforceable by the courts if the restriction is reasonably necessary to protect an employer's legitimate business interest. A quick background on the case. Mr. Couture was employed by Jump Trading International. His contract contained a 12-month non-compete restriction preventing him from working for a competitor after his employment ended. He resigned on 30th of March 2022 after accepting a job with Verition Advisors. He was placed on garden leave for his 12-month notice period. On the 31st of March 2022, Verition received advice from its lawyers that the restriction was not enforceable. On the same day, Jump told Mr. Couture that he would be subject to a 12-month non-compete period after his garden leave had ended. Mr. Couture said this was unreasonable. On the 12th of July 2022, he informed Jump that he intended to work for Verition after his garden leave had ended. Jump deemed this to be a breach of the restriction. And complex arguments ensued between the two employers, with Jump applying for interim relief and an injunction. If granted, the injunction would instruct him against doing the things that seem to be in breach of the covenant until a full hearing has established whether in fact there would be a breach and to what extent. When deciding whether to grant an interim injunction, the court must address several key issues. Firstly, was there a serious issue to be tried? The court concluded that overall there was a serious issue to be tried in respect of the enforceability against him. Secondly, would damages be an adequate remedy for either party? The court accepted that if the clause was enforceable, Mr. Couture did work for Verition, then an award of damages would not be an adequate remedy for Jump. It also said that if an injunction was granted preventing him from working for Verition, then damages would not be an adequate remedy for him. Thirdly, what would the balance of convenience be if the injunction was granted? Jump had taken over 9 months to issue proceedings and seek an injunction since becoming aware of Mr. Couture's intentions. It took over 3 months to reply to his letter setting out his position, and a further month and a half to seek the injunction. If they'd acted more quickly, a speedy trial could have taken place before the intended start date. Given the considerable delay, the court deemed it unjust to grant him an interim injunction, and Mr. Couture has been allowed to take up employment with Verition. The year garden leave also swayed the decision. This served the purpose of isolating him from work for 12 months, in which time his knowledge of Jump's confidential information would have been significantly eroded. It remains to be seen whether this unusual discretionary non-compete restriction with no provision for offsetting time spent on garden leave will be enforced. The government has announced plans to limit non-competes to 3 months, so even if upheld, the decision may be of limited value to employers wishing to include or rely on similar terms in their contracts. The case does provide some important reminders for employers. Decisions on these cases are fact-specific, so consideration is given to role, seniority, market practice within the specific industry, and the proposed new role. So blanket restrictions for all employees are not suitable. They also need to be reasonable. Longer restricted covenants should only be applied to the most senior people, and only when they present a genuine risk. The case also highlights the importance of employers moving swiftly to enforce restricted covenants without unreasonable delay. And myHR department can draft suitable bespoke covenants. We can also draft letters for employees, informing them of your expectations and their continuing obligations under their contract. Just give us a call or drop us an email.